is punished or punishable. The offence in count 15 is consequently recognizable and grounded in an extant existing law in Nigeria, in which it was defined and described. It is now on good law that a child prepared or filed for offence under a wrong law will not be rendered invalid or incompetent merely on that ground alone, so long as the offence on the charge are known to defined and punishment provided for in an extant law. In the result, the answer to the answer posed earlier in this affirmative involves two counts, that the Terrorism Prevention Amendment Act 2013, under which the offences of count 1, 2, 3, 4, 5, and 8 as well as count C45 and count C45. Custom and Excise Management Act, all contained in Laws of Federation of Nigeria 2004, are extant and existing law, which provide for, under which the offences in the counts of the charge retained by the trial courts are punishable and punished. The offences once more are recognized, cognizable, and ground instant and existing law in force in Nigeria. Assuming without considering that at the commencement of the Terrorism Prevention Amendment Act, the Terrorism Prevention Amendment 13 was repealed, and such is liable to affect the validity of the defendant's trial. I refer to section 98 of the Terrorism Prevention Amendment Act 2022, which provides 98.1. The Terrorism Prevention Act number 10, 2011 is repealed. 2. Any regulation, order, requirements, certificates with respect to the substantive issue. I must start the resolution by outlining the effects of the action of the defendant in failing to put in his defense despite several opportunities afforded him by this court. Generally, including the three options available to him upon the no-case commission to argue that the prosecution has not made out a prima facie case against him to warrant him to enter his defense, or that the evidence led by the prosecution so far had been so discredited upon under cross-examination that it would be unsafe for the courts to convict him. Another option open to a defendant is to put his defense where he will be opportunity to state as present exculpatory evidence in his favor. The third and the final option is to rest his case on that of the prosecution. The defendant in this case choose to make no case submission, and this court overruled his case as charged. Is still not proved. Then the accused will get away with his case on that of the prosecution. By that choice, the accused will have decided not to explain any part in rebuttal of the allegation made against him. See also the position of Supreme Court in the case of Ajibade and State Citation Supply, where the court held, and I quote, "Appellant elected not to give evidence in his defense, but to rest his case on that of the prosecution. The election is within his rights under the law, but the legal effect of the said election is to leave the court of trial free to accept the uncontroverted evidence of the prosecution in proof of the charge, which the court rightly did, in my view." See also the case of Hakim Ibisen versus Olajide Citation Supply. The defendant in this case deliberately refused and failed to call any witness, and present evidence to his witnesses, a reporter of the case of the prosecution. The implication is that he admits the case of the prosecution, and the court is entitled to rely on the uncontroverted evidence led by the prosecution. With respect to count 1 of the charge, the defendant is facing the charge of committing an act in furtherance of an act of terrorism against the Federal Republic of Nigeria by making a broadcast received, and in this case is a person. He is known as Nnamdi Kanu. A man is in 50 who stood trial before this court. Thus, the first ingredient is resolved in favor of the prosecution. For the second ingredient, the prosecution led evidence showing that the action of defendants in making broadcasts threatening that people will die constitutes a terrorist act. Terrorism or a terrorist act, according to online Oxford Dictionary, is, I quote, the unlawful use of violence, intimidation, especially against citizens in the pursuit of political aim, unquote. Constitutional, economic, social structure of a country or international organizations. 4. Otherwise influence such governments or international organizations by intimidation or coercion. C. Involve or causes, as the case may be. 1. An attack upon a person's life which may cause serious bodily harm or death. 2. Kidnapping of the persons. 3. Destruction to governments or public facilities, transport system, and infrastructural facilities, including an information system, a fixed platform located on the continental shelf, a public place, private properties, likely to endanger human life or result in major economic loss. 4. The disposal of an aircraft, ship, or any means of public or good transport and diversion, or the use of such means of transportation for any of the purposes in paragraph B4 of this subsection. 5. The manufacture, possessions, acquisition, transport, supply, or use of weapons, explosion, or of nuclear, biological, chemical weapons, as well as research into development of biological and chemical weapons without lawful authority. 6. The release of dangerous substances, causing of fire, explosion of flood, the effect of which is to endanger human life. 7. Interference with or destruction of supply of water, power, or any other fundamental natural resources, the effect of which is to endanger human life. D. An act or omission in or outside Nigeria which constitutes an offence within the scope of counter-terrorism protocol and convention duly ratified by Nigeria. The Supreme Court, by my noble Lord Kekerekun, JSC now the CJN, heard in Abdul Mumuni versus Federal Republic of Nigeria, and I quote, Section 15(2) of the EFCC Act provides, any person who commits or attempts to commit a terrorist facilitates the commission of a terrorist act, commits an offence under this act, is liable on conviction to imprisonment for life. Section 46 of the Act provides, terrorism means any act which is a violation of the criminal code or the penal code and which may endanger the life, physical integrity, freedom of, or cause serious injury or death to any person, any number or group of persons, causes or may cause damage to public properties, natural resources, environmental or cultural heritage, is calculated or intended to intimidate, put in fear, coercion, or induce any government body or institution in general public or any section thereof from doing any act or to adopt or abandon a particular standpoint or to act according to certain principles or to disrupt any public service, the delivery of any essential service to the public, or to insurrections in a state, any promotion, sponsorship of or procurement of any person with the crucial aspect of offense of terrorism is fear and anxiety, both physical and psychological, in the mind of members of the public, which has the effect of coercing, forcing, intimidating them to do or abstain from doing any act or to adopt or abandon a particular view, policy, or position to act according to certain principles or goals. See also the case of Berende versus Federal Society. My research, I came across a handbook from the United States Institute of Peace titled Teaching Guide on International Terrorism, Causes and Responses, where several definitions of terrorism were given as follows. I quote, the calculated use of violence, the threat of violence to inculcate fears, intended to coerce or to intimidate governments or society in pursuit of goals that are generally political, religious, or ideological. Terrorism constitutes the illegitimate use of force to achieve a political objective when innocent people are targeted. Terrorism is defined here as the current use or threatened use of political motivation where you will become free by peaceful means, unquote. The defendant also lent support for violent acts when he said he welcomed what a group known as Biafra Zionist group did when they unleashed violence at the Enugu State Government House. He even said he hoped more people will come out to join his group to overthrow the corrupt and inept persons in administration of the government, stating that Biafra must exist and it is their right to make sure it happens. In the broadcast of 16th May 2021, also contained in Exhibit PWW, the defendant in the beginning of the broadcast stated thus: "My name is Mazi Nnamdi Kanu. I am the leader of indigenous people of Biafra, IPOB, and director of Radio Biafra and Biafra Television. I will remain a loyal servant of the people of Biafra." He further